My lords, my lords, in the Hawker's matter, my lord, I beg to make a mention, my lord, some modifications of the order, my lord, to some extent, my lord. If my lord may be pleased to list this matter tomorrow, because the timing has really created an economical unviable, my lord, Hawker's, my lord.
Take out a formal application.
I'm sorry, my lord.
Take out an application.
It's already been filed, my lord.
Filed,
my lord. If my lord pleases, my lord.
Yes, tomorrow.
My
We
lord.
list it tomorrow. Give notice to all.
My lord, I'm deeply obliged.
Item number 1.
This is the airport expansion matter, my lord. My lord's order dated of 5th May 2025, my lord.
Yes, Mr. Khan.
Lordship, you're just waiting for one more copy. You just received a copy just now, Your Lordship. Just an action taken report.
Okay.
So, Lordship, can you just bear with us for as per the last order, Your Lordship, on 15.5, the direction was given by the court for the steps taken on the action taken report. Lordship, there has been a substantial progress. Lordship, will kindly just go through it. Apology, Lordship, just one more copy. Just coming. We just received a copy.
Can I have a copy, sir? Copy for me? To me? You have.
Apology, Your Lordship. We just couldn't give it early.
Mr. Mosika,
Well,
the central government tender for that infrastructure building?
my lord, the tenders have been opened, my lord. L1 has been identified. The work order will be issued, my lord, only after the land is handed over. That's one aspect, my lord. And the second aspect is that there are certain hillocks, my lord, on the pathway of the aircraft landing. So those have been identified and proposal has been submitted to DGC, my lord. But the cost of removal of those hillocks is quite humongous, my lord. So state government has submitted a proposal seeking exemption from removing some of them, my lord. So we are taking up the matter with DGCA. In fact, there were some queries from DGCA. We have submitted that to DGCA, my lord. So the update, my lord, as far as tender is concerned, my lord, a tender has been opened. L1
You're appearing for the Civil Aviation Ministry?
for Airports Authority. So work order, my lord, since L1 has been identified, we will issue is subject to handing over the land by
The Airports Authority is under the Civil Aviation Ministry.
my lord.
And
The civil aviation is a statutory authority, my lord. Director Director General of Civil is a statutory authority, my lord. They look after the safety aspects of the international norms or the things, my lord.
no, who will take the final call for the central government as far as approving the infrastructure and building the infrastructure is
Well,
concerned?
that has been approved. Well, there is no obstacle any further in that.
No, which is the authority? Airports Authority?
Airports Authority.
You have to take some final approval from some other authority.
No, my lord, because we are awaiting handing over of the land by them, my lord, by the state government. Because there are two components of land, my lord. 10.3 acres is army land, my lord,
We have seen
and
that.
the remaining is private land. So they have to completely hand over the land to us, my lord, and then we'll be able, in a position to issue the work order for commencing of the construction work, my lord. So that is one aspect. Second aspect is, my lord, once the airport the construction work is complete, my lord, they call it ILS flight procedure, my lord. How the aircrafts will land. So and it appears that there are some obstacles, some hillocks and some trees are falling in that flight trajectory, my lord. So for that, whereas state is saying that it is on the state to remove all that, my lord, all those obstacles. State is saying that the cost of removing some of them will be very high. So there is a provision for exemption by the DCCA, my lord.
DCCA is what is the full form?
Director General of Civil Aviation. Director General of Civil Aviation.
That is under the Civil Aviation Ministry.
My lord, it is, they are as such independent, my lord. They are statutory, they have to follow the regulations, my lord.
So, Airport Authority of India is under the.
It is under Ministry of Civil Aviation.
No, it is under Director General of Civil Aviation.
No, my lord. Director General of Civil Aviation is, they only take care of, my lord, the safety aspect of, and even the pilot licensing and the flight procedure, landing procedure and takeoff procedure, the safety aspect, they look into that. So, my lord, in fact, there is a series of meetings being held, my lord, in right earnest, represented by the Civil Aviation Ministry, the Airports Authority, and state government is cooperating. Now, there are two aspects, my lord. They have to hand over the land to us so that we can issue the formal work order to the contractor, my lord. That's one aspect. Second aspect is, parallelly, we are pursuing the matter of exemption of some obstacles with the DGCA, my lord. State government is given a list that the cost of removing or some hillocks, my lord, will be very huge. So there is a provision for exemption.
But in the meantime, you can finalize the agreement and keep it conditional upon handing over of land, commencement of work.
My lord, the private land.
Why should you wait for transfer of land
My lord.
to execute the agreement for infrastructure?
No, because work has to be executed in that very land.
Yes.
Which land?
So you execute the agreement with somebody and keep a condition that it is conditional upon availability of land.
My lord. On that one, lord. But parallel, there's another aspect of the environmental clearance is also under process. So we'll be able to issue the work order only after the environmental clearance is.
So you will issue it from Shillong or from Delhi?
My lord, state government will forward it to Ministry of Environment, Delhi, my lord. That has not been forwarded till now. And that will take another maybe 2 months' time. My lord. If everything goes well, my lord, it will take 2 months' time. So, my lord, primarily 3 issues, my lord: environmental clearance, DGCA exemption to some of the obstacles, my lord, and third is issuance of handing over of land. These are the 3 aspects. What army has said, my lord, as regards the army land, they have said that you can start the work. There is no, they are not objecting to that. But there is a condition that state government has to give them in exchange equal value of land.
No, your officer is also very cooperative. I have met him at the airport,
My lord.
and he is very proactive and very responsible officer. Yes, please. Your officer is the director of civil aviation, Shillong Airport, right?
He is a director of Shillong Airport.
Shillong Airport, yes.
Airport director, Shillong Airport.
This public interest litigation concerns development and expansion of the Shillong Airport. Paragraph. By our last order dated 15th May 2025, we had noted the efforts taken both by the state and central government to facilitate this process. And had made the application returnable today to receive action taken reports. Mr. Khan, learned additional Advocate General for the state, hands up to this court today a note prepared by the state government, , in this matter. Full stop. We direct that this note be made an annexure to an affidavit to be sworn by a competent officer of the state and filed in court by 18 July 2025. Paragraph. On scrutiny of this note, the following are apparent. Stop. Next. For this project, 22 acres of land are required. Stop. According to a draft master plan, RWY is runway.
Yes, madam. Yes.
Runway bracket RWY bracket closed would be extended by 571 meters, taking its total length to 2400 meters. Full stop. On completion of this extension of RWY4, landing operations would be from the runway bracket RWY bracket close 22 and takeoff of aircrafts from RWY4. Full stop. 22 acres of land are required for next. 22 acres of land are required for this, of which 10.3 acres are proposed to be acquired from the defense authorities. Next. Acting on our observations in the last order, it seems that the cabinet, our last order, it seems cut off. The cabinet on 4th Now, the Cabinet of the State Ministry on 4th June 2025 has approved acquisition of this land for rupees 72,17, 56, 237 by private sale by private cutout by sale agreements with individual landowners. Full stop. The land is expected to be acquired by July 2025. Next. The Ministry of Defence has on 17th April 2025 has accorded sanction to the state government to work on 10.30 acres of military land at Umroi Military Station, Shillong. On an agreement between itself and the state for exchange of for transfer of land by the state, transfer of land of equal value by the state to the ministry. Paragraph. Learned Deputy Solicitor General Dr. N. Mozika, appearing for the Airports Authority of India, on instruction from the Director, Shillong Airport, submits that the tender for carrying out construction, renovation, and alteration of the infrastructure of the airport would be granted by the Airports Authority of India to a contractor immediately upon receipt of land from the state and defense authorities and on obtaining the necessary environmental clearance. Dr. Mozika also submitted that his client, the Airports Authority of India, would also have to resolve some impediments caused by presence of mounds, trees, etc. along the flight path to the airport. Full stop. These obstructions have also to be removed. Paragraph. On examination of this report, we find that now the essential preliminary groundwork which was required to be made for expansion and development of the Shillong airport has been done. Nevertheless, we are of the view, that a substantial amount of work is required to be done to make the project operational. From now, expeditious steps should be taken by all authorities concerned, which include the Ministry of Defence, the State Government, the Airports Authority of India, and the Director General of Civil Aviation to apply the necessary thrust to the project so that the expended and developed Shillong Airport becomes operational as soon as possible. We make this application returnable once again on August 12th to review the progress of the work. Short action taken reports may be filed by all authorities who are represented in court today.
Lordship.
Obliged.
Number 2.
Lordship, item number 2, just receiving. Lord, the matter is still pending before the Honorable Supreme Court, and your Lordship may kindly see earlier order may further be renewed, my Lord.
All right. You mention, as mentioned in our order dated, add one order, 1st May 2025, and the writ petition is further adjourned till 18th August. Mr. Advocate.
Yes, please.
Correct.
Number 3.
Yes.
Lordship will recollect, I had started my argument. My learned senior friend had finished his argument and I had started my argument. Just to refresh back the brief facts, Lordship. Lordship, this is a case where FIR was lodged against an accused,
Yes.
alleging that she had killed her husband. Also, made an attempt to.
1 minute, Mr. Are there any similar matters after this?
Yes.
Five to 19. Similar.
Item number 4.
For your fault.
Lordship may have this matter next week, my lord, because I will be praying for filing of paper book in item 9, my lord, which has all the documents, my lord, in presence. So next week, your lordship may have it.
What is this MC?
Miscellaneous application for condonation of delay. Your lordship has held that all matters will be heard together. Matter will be heard on merit.
Delay has been condemned.
Delay.
Delay was 200 days plus.
Yes, your lordship. In some matters, there was different delays in different dates, my lord. That was argued and condoned, my lord. Matter is being heard on merit, my lord. On last
Oh,
day.
delay is condoned.
Delay is condoned, my lord.
So why is MC appearing in the list?
Stay.
Any order first here? There is already a direction for filing paper book.
Yes, my lord. I have filed the paper book in the lead matter, my lord. But lead matter, my lord, if your lordship will see
21.
21, yes, my lord. But I have already filed, my lord. But in the lead matter, my lord, all the papers, all the documents filed by respondent and the petitioners are not there. I was praying, my lord, that I may be permitted to file paper book in item 9, where all the documents are there, state of Meghalaya. They are all connected against the common judgment and order, my lord.
Or would you like it in that way, or a supplementary paper book?
Supplementary paper book that will
to extract all the papers which
ma'am.
are left out.
Yes, ma'am. Supplementary will be convenient, my lord. I will file supplementary one.
All right. The paper book in the appeal, WA number 21 of 2025, has been filed. Full stop. However, Learned Advocate General during the course of hearing of this appeal, of these appeals, submits that this paper book does not contain all the documents which are involved in this batch of appeals. Full stop. Some documents in the appeal WA 9
25 of 2025, my lord.
25 of
2025.
25 have not found a place in the paper book. Next, since one paper book is being used for all the appeals, we grant liberty to the advocate on record for the appellant to file a supplementary paper book containing the papers which have been left out by 21st July.
Yes, my lord. Will do.
By 21st July. Serving copies thereof on the advocate on record for the respondents. Make it 23rd. List these appeals once again on 8 July. Correct?
Obliged. You can call item number 3.
Lordship, just to refresh the brief fact, on 28 March 2003, an FIR,
Son was killed by the father, the mother killed the father.
Lordship, as per the FIR says a man and a young boy has been killed and one daughter has been injured. So this was an FIR of 28 March 2003. Now, the most important issue, Lordship, yes, in this case is that at page 40, I read out the other day, Lordship, of the impugned judgment, where the confessional statement, in this case, Lordship, there is a confessional statement by the accused.
Yes.
So page 40 is the confessional statement that the court relied on, and para 41, Your Lordship, of the judgment is the detailed discussion. Lordship, para 40 is at page 104 for easy reference of this Honorable Court, Your Lordship. Page 104 of the is the para 40 and para 41 is page 105. One zero four, 105. most important part in the judgment, Your Lordship, is at page para 40, with the trial court while recording that statement. Lordship, para 40 from the top, the 9th line. The trial court has observed within bracket, Your Lordship, that though 164 CRPC was recorded on 29 March 2003, although it was not exhibited, where she stated the details. The legal issue involved here, Lordship, here is that in para 40, this document was not exhibited. And what was the contents of this document, how the court appreciated it, was in para 41. So, Your Lordship, basically, the law on this issue is very, very clear. Even if the document is not exhibited, it's not fatal. Why I'm pointing out the non-exhibiting, Your Lordship? The learned senior counsel for the defense had argued that since the document was not exhibited, it could not have been acted upon. Lordship, the other day I relied on section 80 of the Evidence Act. So exhibiting is not mandatorily required.
Let us see 80 again.
Section 80, Lordship, of the Evidence Act. May it please Your Lordship, if I...
Yes.
Your Lordship, Section 80 deals with statement of confession by an accused. We are concerned specifically, Your Lordship. There are varieties of, it contemplates a multiple situation, what can this section take care of. Our specific case, Your Lordship, is this: if a confession is made by an accused, taken in accordance with law and purporting to be signed by any judge or magistrate or by such officer as aforesaid, the court shall presume.
So it need not be rooted as an exhibit. You can just show it to the judge.
Absolutely, Your Lordship. I'm grateful, Your Lordship. That is exactly
like you show court orders.
Absolutely, Your Lordship. And the word uses, the court shall presume that the document is genuine. That any statements to the circumstances under which it was taken, purported to be made by a person signing it, are true. Statement are true, signing are true, and that such evidence, statement or confessions was duly taken. Shall presume to be true, the signs are true, and the confession statement that are made in the documents are true. So in other words, Your Lordship, the observation in paragraph 40 does not require under law, it should be exhibited. And the trial court rightly, Your Lordship, at paragraph 41 had discussed in detail. Your Lordship, the other day a query fell from this Honourable Court, Your Lordship, about the content. Though section 80 takes care of the document itself, which is not to be exhibited, and the confession in the document shall presume to be true, signed to be true, and shall be used as an evidence. One small lordship window, if at all defense had, of course it's not their case at all, Your Lordship, because they have not argued the case on the inadmissibility of the content, but they had an opportunity, though it's not the case before the Honorable High Court, and their opportunity, Your Lordship, is taken care under 463 of the CRPC. 463, Your Lordship. If I take Your Lordship to 463 of the first submission of prosecution, Your Lordship, is the trial court has rightly acted. But assuming, Your Lordship, if that proposition comes up only for the purpose of academic, though it's not their case and not their argument, but let us see how do we answer that issue even. 463 of CRPC, Your Lordship. May please, Lordship, if I just read the relevant part of it.
Yes.
Lordship, 463 is a very important provision. Now, Lordship, before we read this 463, Lordship, just want to make a small analogy, Lordship. There is no provision in the CRPC whenever a statement is recorded under 161 by the police, because that is itself is not admissible under section 25, 26 of the Evidence Act.
Yes.
But so far 164 is concerned, Your Lordship, an additional protection is given because of the sanctity and the substantiveness of the statement made, because it is made voluntarily, Your Lordship.
So what is the sentence awarded by the learned judge?
Life sentence. A case of will come, Lordship, once we fortify the para 40 that is not exhibiting that is not important, and the trial court has rightly considered the details of the 164, then, Your Lordship, it's an open and shut case. The prosecution has proved the case beyond reasonable doubt based on the confessional statement. That is in a nutshell, that's the case of prosecution. And the prosecution has not only proved the case beyond reasonable doubt on the basis of 164, there is corroborative evidence of post-mortem, inquest, there are other evidence. But Lordship, our first argument is this: first, let us protect. So I'm coming to 463, Lordship, to further fortify the argument of the prosecution. Lordship, 463. If any court before which a confession or other statement of the accused person recorded or purporting to be recorded under 164 or section 281 is tendered or has been received in evidence, finds that, in our case, Lordship, it has already been received in evidence in para 40, finds that any of the provision of either of the section has not been complied with by the magistrate recording the statement, it may, notwithstanding anything contained in section 91 of the Indian Evidence Act, this is important, Lordship, take evidence in regard to such non-compliance and may, if satisfied that non-compliance has not injured the accused in his defense on merit, and that he duly made the statement recorded. Last part is important, Lordship. Admit such statement. It is not the case of the defends, Your Lordship, that 281 was not complied. Section 80 is taken care of it. But in case, Your Lordship, if they raise this plea, and I'll come specifically to Your Lordship, what is the provision for them to raise this plea? Even if they raise the plea, Your Lordship,
The technicalities will not be insisted upon by the court.
Lordship. Even if they've raised the plea, Your Lordship, now where they can, the word, very important word, Your Lordship, is this, the accused in his defense. Lordship, I'll be emphasizing on the word defense. Defense in merit, and that he has duly made the statement recorded, admits such statement. Has not injured the accused in his defense. This is very important, Your Lordship. And what?
The learned judge has held that you have been
Yes.
able to prove your case.
Lordship. No, injured the defense is very, very important, Your Lordship. Where do you find the opportunity for the defense? The statement of the accused was recorded under 313.
Yes.
We come to, Your Lordship, 314 and 315. 313 is the 313 is the statement recorded under by the accused for explaining the statement. Now, Your Lordship, I'll just take Your Lordship to 315. Yeah. Lordship has got it. 315. Lordship has got it, please.
313.
We are in 315, Your Lordship. So, Your Lordship, 315 is accused persons to be a competent witness. 3114 is a stage where oral arguments are completed and memorandum arguments. Then the opportunity is given to the accused. Any person accused of offence before a criminal court shall be a competent witness for the defence and may give evidence on oath in disproof of any charges made against him or any person charged together with him at any trial. The accused shall be a competent witness, Lordship, at the stage of 313 for defence and may give evidence on oath. Well, Lordship, if you read 463, only if there is an injury to his defence as a witness, that is a very, very limited small window open to the accused, and that too after the oral argument is over under 314. In other words, Lordship, the accused has to present itself in the witness box and challenge the content and the procedure by becoming a witness on oath, and the prosecution here, Lordship, will have an opportunity to cross-examine. Now, Lordship, if I take Your Lordship to page 88,
315, what is the other section you put in?
Lordship, first is 313, 314, 315. Lordship, if I take Your Lordship to page 88, the statement on 313. No, where he says he doesn't want to leave. Lordship, will just come straight to page 89 to answer 315, whether there is a factual basis for 315. It's an admitted fact the accused had never presented herself as a defense witness. Now, where did she say this is very important, Lordship. That explanation she gave under 313 at page 89, question number 16. Page 89, Your Lordship. Question number 16. She clearly says when the court asked her, will you adduce any evidence for your defense? I will not adduce any defense witnesses. In other words, Your Lordship, an opportunity, if any, provided to her under the procedure to remotely even shake the 164 statement, which shall presume to be an evidence under section 80. If at all she wants to challenge the content that the accused has under 315 after the oral argument under 314 is over. Here it's an admitted categorical statement. In other words, Lordship, though section 80 of the Evidence Act clearly says it shall presume to be admitted evidence. Now if we read section 80 in tandem with procedure of 463, court will not interfere if there is no case of injury or prejudice or could not present defense by the accused. In other words, the principle of prejudice is taken care of. If you read 463 with 80,
Yes.
para 40 is completely fortified. And the finding in para 41 passes the test of law, passes the test of section 80, it also passes the test of section 463 because accused waived her right under 315 to challenge the content of her own confessional statement. Now, if that is the case, Your Lordship, then we straight come now to what is the confession statement. Lordship, we just come to the confessional statement which was recorded on 2nd April 2003. The type copy is at page 35. Now, should we come to the confession statement? Since Lordship, it's a life imprisonment
Page
and
1.
31335, Your Lordship. It's a type copy.
I think we saw it last time.
Lordship. Lordship, the relevant part for my purpose is line, 7th line, Lordship. From the top, the 7th line. In my anger, I took another dagger and hit my late husband in his neck and shoulder. Lordship, it's a confession of she hitting. Lordship had asked a very important question to me the other day. How do we know what happened inside the room? Because PW2, Lordship is aware, PW2 clearly saw her coming out from the room with a dagger on her hand, and the accused in front, she was behind, accused making few steps ahead, then falling in the ground and collapsing. That is a different evidence, Lordship. I'll try to connect. But so far, what happened inside the room, that's why, Lordship, I was taking time in section 80 and 463, because if we can fortify the 164, what happened inside the room is an evidence. Lordship, what happened inside the room is an evidence that has sprung up, remain unshaken, proved under section 80, passed the test of 463.
No, that is absolutely all right, because it is very difficult to get evidence of somebody actually seeing somebody shooting.
Correct.
Or somebody lifting a dagger and
Correct.
piercing it into somebody's body.
Lordship. So that's why, Lordship.
Or somebody committing rape, the act of it.
Lordship.
It is all from the surroundings.
Absolutely, Lordship. But this case, Your Lordship, this particular evidence, piece of evidence stands in a higher footing. That also stood proof what happened inside. On the statement of the accused herself. So this becomes a foundational fact, which is substantive piece of evidence as to what happened.
No other defense was taken.
No.
Like
No.
provocation or
No, Lordship, no.
nothing.
No. Nothing as such. It is not the case that she was provoked and this is nothing. But there was an element of affair involved, Your Lordship. But that again, Your Lordship, as I submit.
Or loss of mental faculties.
No, absolutely. Lordship, I'll answer that query because immediately on our arrest, I'll come to the medical report. That part also, Your Lordship, that is where we're trying to build up. First, Your Lordship, we have laid the foundation of 164. Now we have knocked the door, the prosecution has knocked the door and entered the crime scene. And what happened in the crime scene? She says, in my anger, I took another dagger and hit my husband in his neck and shoulder. Lordship, after full stop, very important. Then I hit my daughter, who is 2.8 years old, from the back of her neck towards the back side of the head 2 times. She has been convicted for 302 for killing her husband. She has been convicted by the learned trial court under 326 for hitting her daughter with a dagger. The medical examine clearly proves corroborated, Lordship. Now, what she has not stated is, Lordship, if your Lordship will see the third line from top.
Page?
Same page, Your Lordship. I'm reading the confessional statement.
However, I did not want to give.
Lordship. No, if you come, Lordship, 1, 2, 3, 4, 5. The 6th line, Your Lordship. Let's come to the confession part where this particular, because the son also was dead, Your Lordship. She says, my 4-year-old son was having rice and my late husband hit the boy's neck from the left side 3 times. My son slumped to the floor. Lordship, this is not a confession statement. Law is very clear. This is basically what is otherwise known in law, Lordship, is known as exculpatory statement. The other part where she says she has hit her husband and her daughter, that comes with the meaning of inculpatory. Larger context is confessional, and the specific term is inculpatory. So far son is concerned, Your Lordship, she says that is an exculpatory statement. Lordship, if you pause for a minute, of course this is a different argument that I'll be forwarding, provided Lordship allows me to answer this issue even.
Certainly.
This is a false statement she has made, Your Lordship.
We will continue tomorrow. Mr. Khan, additional Advocate General appearing for the prosecution, continues his arguments but does not conclude the same. Let this appeal retain its position in the list tomorrow.
Much obliged.
Obliged.